this headline story now. The Western Cape High Court will hear an application this morning by Public Protector Advocate Busiswe Mkhwebane to interdict Parliament's motion calling for her removal from office. Now, she is challenging the constitutionality, the lawfulness and validity of the procedure the National Assembly is using to determine her fitness to hold office. The Public Protector has previously said that the rules for her removal are unconstitutional and that they violate the independence of Chapter 9 institutions. Thandi Modise is opposing that application. Let's unpack the story now. We're joined on the line by Lawson Naidoo, who is Secretary at the Council for the Advancement of the South African Constitution. That's CASIC. Lawson, as always, a pleasure talking to you. So the Public Protector is challenging this bid by Parliament, this motion by Parliament calling for her removal of office. She said that the rules for her removal are unconstitutional, but on what basis do we know that she is saying that it is unconstitutional?
Good morning, Michelle, and thank you very much. I think we need to clarify up front that this is a two-part application that the Public Protector has launched against the process in Parliament. Part A of that application is what is being heard today and tomorrow in the Western Cape High Court. And this is the application by Advocate Mkhwebane to interdict Parliament from proceeding with the process to remove her from office. So it's to stop the parliamentary process. Part B of the application, which is the challenge to the constitutionality of Parliament's rules to remove heads of Chapter 9 institutions, will be heard at a later stage. So this is a procedural matter that's being heard today. And the Public Protector is seeking to stop Parliament from engaging on the process. The process in Parliament has, in any event to date, been extremely slow. The Speaker of the National Assembly, Thandi Modise, has yet to appoint the independent panel to review the complaint against the Public Protector to determine whether there is, in fact, a prima facie case to be answered. Only once that independent panel has reported will a parliamentary committee be appointed if that panel recommends that the matter should be investigated further. So it is at a very early stage still in the parliamentary process, but the Speaker is opposing this application for an interdict, arguing that Parliament should be allowed to continue with its processes to start the process of the removal of the Public Protector.
I mean, the grounds for the removal of someone like the Public Protector in Section 194, it looks on the face of it to be transparent. You know, it's on the grounds only of misconduct, of incapacity, of incompetence. I'm just wondering, Lawson, what's contained in the papers by the Public Protector to argue that this goes against the Constitution?
Well, I think, as you said in the introduction earlier, this is really an example of the Public Protector clutching at straws. She's basically, if you, look through the arguments carefully, she's basically saying that Parliament can't hold her to account, that as part of this Part A interdict today, she's arguing that members of Parliament who have commented on her suitability to hold office, directed primarily at members of the Democratic Alliance who have been vocal in their opposition to her, are conflicted and should not be able to participate in that process. Now that strikes at the very heart of freedom of speech of members of Parliament and goes to the very heart of the role of MPs in Parliament to raise issues of national and public importance. So this is clearly an attempt by Advocate Mkhwebane to evade accountability and she's effectively arguing that nobody can hold her to account.
Because on the flip side of that, Lawson, if you are confident in your ability, confident in the way your office has conducted its business, would you not welcome this kind of scrutiny?
Well, absolutely. When there are allegations of this nature flying around, the opportunity to clear your name should be something that you would grasp with both hands. But we know that the Public Protector is on extremely thin ice in these matters. There was yet another court matter last week where her advocate basically conceded to the court that the Public Protector had misled the court by not acknowledging that she had in her possession a confidential State Security Agency report court. She told the court initially that she did not have it, and then conceded last week that she in fact did. So whether somebody like that is, that's an example of clear gross misconduct. And I think the real point here is whether someone of her ilk can really be trusted with holding any public office, let alone that of the head of a Chapter 9 institution.
Lawson, how politicized is the appointment of the public protector? I mean, ideally, it shouldn't be. It should be, quite a transparent process that can stand the scrutiny of any court if it comes to that. But how politicized has it been, particularly as we talk about the appointment of Advocate Busiswe Mkhwebane, who, since the start, has just her time in office has just been shrouded under a cloud of so many questions about her understanding of the law?
Well, I think that's a critical issue you raise, Michelle, because while Parliament's processes are indeed transparent, the interviews are conducted in public, etc., the process lacks robustness in that there are no objective criteria that are set down. Candidates are not objectively measured against a set of criteria to determine whether they have all the attributes to hold such an office. We saw yet another example just in the last few weeks when the Minister of Police recommended a candidate for appointment as the head of IPID, and Parliament proceeded to endorse that recommendation without ever seeing or interviewing that candidate. So parliamentary processes certainly need to be strengthened and beefed up to ensure that only the best candidates get through. But unfortunately, even if that were to happen, the politicization of so many of these positions for high public office are indeed politicized, and we see splits, with the ANC backing candidates that are nominated by members of the executive in the case of IPID, or in the case of the Public Protector and other Chapter 9 institutions. Party political allegiances come to the fore rather than the national interest.
I mean, it just takes away from the job of a Chapter 9 institution. I mean, they're established in terms of Chapter 9 of the Constitution, and their mandate is to guard democracy. So for there to be so many questions for the office of the Public Protector, that just defeats the purpose.
Well, indeed it does, and I think that the appointment of Advocate Mkhwebane and her conduct since being in office for almost 4 years now, has certainly undermined the integrity and the respect that that office has amongst ordinary South Africans, and as an important bulwark against the abuse of state authority and state power. It has become less and less efficient, less trusted by members of the public, and therefore has taken away the key mechanism that ordinary members of the public have for easy access to justice.
Yeah, absolutely. Well, Lawson Naidoo, as always, thanks very much for helping us understand what is a bit of a complicated issue in court today. Lawson Naidoo is Executive Secretary of the Council for the Advancement of the South African Constitution, and there are two parts to this issue around Advocate Busiswe Mkhwebane, who is the Public Protector. Today, we're in court to interdict Parliament's motion calling for her removal from office. That's a developing story that we'll continue to track for you.